Hello everyone, welcome to Drishti IAS. UPSC Prelims 2026 is knocking on your door, so we have brought to you a series wherein we cover these core subjects, the high-yielding topics that are asked in the UPSC preliminary examinations. And in today's video, we are going to be revising the subject of polity with the help of MCQs. And this series is called Revision with MCQs. So without further ado, let's take a look at what is the first question in store for us in our question bank. Question 1 says, consider the following statements regarding the Indian Constitution. 1. Article 3 deals with the internal reorganization of existing states, including alteration of boundaries and formation of new states within the Union. Article 2 relates to the admission or establishment of new states that are not part of the Union of India. And we have to figure out which of these statements given above are correct. Now, in order to understand this, let's first take a look at part 1 of the Indian Constitution, in which articles 1 to 4 deal with the Union and Territory of India. What does Article 1 say? Article 1 says that India or Bharat is a union of states. This means that this article defines or gives the name of the polity that we are in, also the type of the polity that we are in, meaning that it's a union and not any other form of polity like a federation. What does Article 2 talk about? Article 2 talks about the admission or establishment of new states within the Union of India. Admission means incorporating something that is already existent. Establishment means creating new states, territories, etc. Now, Article 2 is talking about those territories that are not already a part of the Union of India, that are external to or outside the Union of India. Hence, we are talking about admission, incorporation, right? Then there is Article 3, which talks about internal reorganization, meaning this also talks about formation of states or changing of boundaries or changing of names of the states, but very much within the Union of India. So this deals with internal reorganization. How can new states be formed? How is a union internally reorganized? By formation of new states. How can new states be formed? Either by separating from a state a certain territory. So let's say this is separated, or by bringing together of 2 or more states. So this becomes another new state is formed, or by bringing together a territory to another part of the state. So here again, a new state is formed. These are the ways that are mentioned in the Constitution. But other than this, there is also the mention of either augmenting or diminishing the area of state. So Article 3 is dealing with either increasing the area of state, also decreasing this area of the state, or for changing or altering the boundaries of the state, or of altering the name of the state. So these provisions are dealt with in Article 3. Here we see that this is talking about all these alterations and all these modifications within the Union of India, within the territory of India. Hence, it is dealing with something internal, and Article 2 was dealing with something outside of Union of India. And then we have Article 4, which says that any amendment to the Constitution made for the purposes of either Article 2 or Article 3 will not be considered a constitutional amendment under Article 368. So this is the whole idea of Articles 1 to 4. Now that we have this information, let's go back and attempt the question that was given to us. So first statement said Article 3 deals with the internal reorganization of existing states, including alteration of boundaries and formation of new states within the Union. This statement is accurate. We just talked about how Article 3 deals with internal reorganization. Second statement says Article 2 relates to admission or establishment of new states that are not part of the Union of India, and this statement is also accurate. With this, we have both 1 and 2 are the correct answers, and therefore option C is our answer. Here we have the detailed explanation for you. You may want to pause the video and take a look at it. Question 2. Consider the following statements. 1. Children born in India to foreign diplomats cannot acquire Indian citizenship by birth. And second, a person acquiring Indian citizenship through naturalization must take an oath of allegiance to the Constitution of India before the certificate of naturalization is issued. Clearly, our question here is dealing with the subject matter of citizenship. So let's first understand in what ways can a person acquire or be granted or naturally have the citizenship of India. So, how can someone attain citizenship of India? There are ways to do it. Firstly, by birth. Now, this also has certain qualifications or certain criteria of dates. If you're born between this period and that period, then you are a citizen irrespective of, your parents' nationalities. The other way is by descent. Third way is by naturalization. Is by registration. And then the fifth way is by incorporation of territory. Now, the first statement of our question talked about the children of foreign diplomats that are born in India. Therefore, we are here talking about citizenship by birth. What are the fundamental criteria for a person to be a citizen of India by birth? Well, there are certain dates that we have to take care of. So, any person, any individual who was born in India at the time of the commencement of the Constitution up till July 1st, 1987 is a citizen of India irrespective of the nationality of his or her parents, meaning whether or not the parents are citizens of India. If a person is born between 26 January 1950 and July 1, 1987, that person has the citizenship of India by birth. Then, if a person is born between July 1, 1987 to December 3rd, 2004, then a person is considered a citizen of India if at least one of his or her parents is Indians. All right. So, if at least one parent is Indian, then this person born between July 1st, 1987 to December 3rd, 2004 is going to be considered Indian. Then, of course, we have children who were born after 3rd December 2004 in India. What happens? If somebody is born after 3rd December 2004, then for that person to be an Indian citizen, both the parents have to be Indians. Or if not both, then at least one parent should be Indian and the other should not be an illegal immigrant. So these are the various conditions that have been put upon individuals for them to have the citizenship by birth. Another important thing that one must notice here is any children who are born to foreign diplomats in India or children of enemy aliens, states that we have been at war with. So such children who are born in India are not eligible for citizenship of India by birth. So if we go back and look at the first statement, children born to foreign diplomats cannot acquire Indian citizenship by birth, this statement is accurate. The next statement talks about Indian citizenship through naturalization. Now, when we talk about naturalization, there are also again certain parameters that one must fulfill in order to attain citizenship by naturalization. And those criteria are, so suppose a person belongs to a country which does not restrict Indians from acquiring citizenship by naturalization, then to that person or that individual, we will give, or India will grant, citizenship by naturalization. So that person who belongs to a country which does not restrict Indians to attain citizenship by naturalization are eligible. Secondly, the person who has applied for this naturalization should also be willing to renounce or give up their citizenship of the country to which the person originally belonged. That is the second criteria. The third criteria is that the concerned person, the applicant, should have a good moral character, should be of a good character. And fourth is that the person should know at least one of the languages consisted in the 8th schedule of the Indian Constitution. So if these parameters are met, then the person is granted citizenship by naturalization. However, before such a certificate is issued, that person must take an oath of allegiance to the Indian Constitution. So this statement is also accurate. So again, we have option C as the correct answer, both 1 and 2. Here we have the detailed explanation. You may pause the video and take a look at it. Question 3. Consider the following statement. 1. Registered overseas citizens of India, cardholders are treated at par with non-resident Indians or NRIs for the purpose of inter-country adoption of Indian children. And second, OCI cardholders do not require any special permission to undertake research work in India. Now, who are OCI cardholders? Who are overseas citizen of India? So, they are basically foreign nationals of Indian origin. OCI cardholders are mainly, or OCIs are mainly, foreign nationals of Indian origin to whom the government of India has granted a special status. Now, here again we have certain criteria, certain date meeting which a person can apply for an OCI card. So what are those criteria? So if a person or a foreign national basically were citizen of India at the time of the commencement of the Constitution on 26 January 1950, then that person is eligible, or at any point after that, then that person is eligible to be a citizen of India. Then any person who were eligible to be citizens of India at on 26 January 1950, that person also is eligible to be an OCI card holder. Meaning, if you were already a citizen on 26 January 1950 or at any point after that, or if you were eligible to be a citizen of India on 26 January 1950, in both the cases, you are eligible to be an OCI card holder. Again, if there were individuals who belonged to territories that were acquired by India after independence, after 14th August 1947, then you are eligible to be an OCI card holder. Again, children, grandchildren, and great-grandchildren of these individuals are also eligible for application. Again, minor children whose both parents are Indian citizens, or if one parent is an Indian citizen, are also eligible to be an OCI card holder. Next, of course, we are dealing with spouses. Now, if a spouse is of foreign origin but is married to an Indian citizen, or if a spouse is of foreign origin but is married to an OCI card holder, then in that case, the spouse is also eligible to be an OCI card holder. So, this is the criteria. Now, it has a lot of facts and dates, so that you'll have to remember, just like in the case of citizenship. Now, there are also certain benefits to an OCI card holder. There is a reason why foreign nationals of Indian origin try and apply for this card, for the OCI card. And benefits include multiple entry lifelong visa for visiting India for any purpose. So, of course, they do not have to keep applying visa every time. Their visa is lifelong and multiple entry. And they can visit for any purpose. However, if they want to undertake research work in India, then they must apply to the concerned Indian ministry or mission or post. Alright? So, this makes our given statement incorrect. So, of course, when we talk about the second statement, it says OCI card holders do not require any special permission. No, they do, because they must inform the concerned mission, ministry, post, right, or their nearest registered offices. So, therefore, this statement becomes incorrect. However, within those benefits, it is also mentioned that registered OCI card holders are treated at par with NRIs when it comes to the purpose of inter-country adoption of Indian children. So, this is indeed a benefit that OCI card holders do avail. So, this statement is correct. So, we have option A as the correct answer, which is one only. Now, this is the explanation in detail. Kindly pause the video and take a look. Question 4 says, consider the following statements regarding Article 12 of the Indian Constitution. 1. Courts are considered states when performing judicial functions, but they are not treated as states when exercising rule-making powers. Now, this is a very interesting statement. Courts are considered as state while performing judicial functions. Now, what exactly is state according to Article 12? Article 12 of the Indian Constitution talks about what is state. And state is considered to be any authority whose actions can be challenged in court. Whose actions can be challenged in court for the violation of fundamental rights. Now think about it. While performing judicial functions, the court becomes the interpreter, right, or the adjudicator. So, can somebody challenge the judiciary itself for the violation of fundamental rights? No. Therefore, it cannot be considered state, or courts cannot be considered state when they are solely performing or performing purely judicial functions. However, if they are performing administrative or rule-making functions, so for example, they are deciding the procedure of courts or other rules of conduct, then they are considered as state. So, first statement has been actually reversed. When performing judicial functions, courts are not considered states. Whereas, when performing administrative and rule-making functions, they can be considered state. Hence, the first statement is incorrect. Second, all the local authorities such as municipalities and panchayats fall under state. Here again, let's take a look at Article 12. What all bodies or what all authorities are included under the definition of state? So we have the government and Parliament of India. We have the government and legislatures of state. We also have local authorities like municipalities, panchayats, district boards, improvement trusts. All of these come under state due to the definition of Article 12. And finally, we have other authorities like, for example, ONGC, SAIL. So, these are included in the definition of state under Article 12. And with this, if we look at the second statement, local authorities such as municipalities and panchayats do fall under the state, therefore this is correct. And we have two only, or option B as the correct answer. I hope things are clear by now. Explanation in detail, please pause the video and take a look at it. It is an important thing to note here that there are cases like the A.R. Antule versus R.S. Nayak and the N.S. Mirajkar versus State of Maharashtra cases, where the court has held the same thing, that the judiciary is considered state when they are performing purely judicial functions, but not considered state when they are performing purely judicial functions, but are considered state when they are performing rulemaking or administrative functions. So this is something that you might want to remember. Question 5. Consider the following statements regarding the doctrine of severability. Now, before we look at the statements, let's first try to decode what doctrine of severability means. What does the term sever mean to you? So when we talk about sever, we talk about severing ties, severing a connection. So the term sever in itself means cutting off or separating. So needless to say, the doctrine of severability must also be dealing either with cutting off or with separating. So let's understand what this doctrine of severability is in simple words. Now, if a part of the law, according to doctrine of severability, if a part of the law is in conflict with the Constitution or is inconsistent with the fundamental rights that are given in the Constitution, then only that part of the law is considered invalid or is struck off, provided it is separable from the other parts of the very same law. So, it simply means that to the extent a part of law is inconsistent with fundamental rights, to that extent only, or it can be considered invalid to the extent of inconsistency, so far as it is inconsistent. For example, if we understand it with the help of a simple example, suppose a law is made which prohibits publishing opinions along with organizing public meetings. What happens in this case? Now the judiciary might look at it and say, well, under reasonable circumstances or under some circumstances, maybe conducting public meetings is not going to be very feasible. It's not going to be a viable option without, say, affecting the security of the state or something to that effect. So this, they might actually retain that this part seems all right. But this part, putting a ban on publishing opinions, is in direct contradiction with Article 19, which talks about the right to freedom of speech and expression. And therefore, to the extent the law or a part of the law is inconsistent with the fundamental rights, to that extent, this may be considered invalid. So the court may strike off this part but retain this part because they are entirely separate and one is not related to the other. All right. So this is the meaning of doctrine of severability. Now that that is clear, let's go back to our question. Statement 1 says the doctrine applies when a legislature lacks the power to make a law on a subject but still indirectly enacts one. No, students, this is not what severability means. This in fact is a description of colorable legislation. This is the doctrine of colorable legislation. What is colorable legislation? This is also called fraud on the Constitution. Fraud on the Constitution. So, according to colorable legislation, what happens is that, let's say, the legislature, the state legislature, does not have the authority to form a certain law. It is, or there is a limitation on their authority to form certain laws, frame certain laws. Now, the legislature bypasses that authority or bypasses that limitation and indirectly frames that law. That is called the doctrine of colorable legislation. In simple words, students, you cannot do indirectly what you can do, what you cannot do directly. You should not be doing something bypassing the order if you cannot do it directly. That is the whole idea. How can we understand it? Let's say the state legislature cannot frame a law on taxing income. All right, because that is a union subject. So let's say it cannot frame a law on taxing income. So what it does? So for the farmers, it comes up with an agriculture development fee, which is basically an income tax disguised as a fee. So this is doctrine of colorable legislation in action. What you cannot do directly, you are doing indirectly. All right. So with this, we understand two important doctrines. Now, this is wrong. The second statement says the doctrine is rooted in Article 13 of the Indian Constitution. This is absolutely accurate. It is Article 13 indeed, which says that if a part of the law is inconsistent with any fundamental right, then the part of the law is invalid to the extent of that inconsistency, as we have just read a while ago. So this statement is correct. And again, we have two only, or option B as a correct answer. Again, the explanation in detail. Please take a look at it. The doctrine of casus omissus primarily means that casus omissus literally translates to a case omitted. What is omitted or what is omission? So omission basically means withholding or leaving out. Withholding or let's say leaving out. So now that we have the meaning of omitted, let's try and understand what this could mean. It means that the courts cannot fill by words any gap that has been either inadvertently or deliberately left out in a statute or law by the legislator. Meaning that if there are some gaps in the language of a given statute, then the court cannot fill those gaps. The courts cannot take up the role of a legislator. So this also ensures a separation of powers. The judiciary or the courts retain their power of interpretation, while rule making, law making is left to the legislature. So this is what this means. Casus omissus. So courts may infer missing provisions in a statute. This is the exact opposite. Option B says courts cannot insert into a statute what the legislature has either deliberately, means intentionally, or inadvertently means unintentionally left out or omitted. So option B here again is the correct answer. So this is the explanation in detail and you might want to take a look at it. Please pause the video to do so. Question 7. With reference to Article 19, Clause 2 of the Constitution, consider the following restrictions on the right to freedom of speech and expression. Now, right to freedom of speech and expression is a part of the right to freedom, right? So, we have various freedoms that are granted to us by Article 19 of the Indian Constitution. Right to freedom of speech and expression, right to assemble peaceably and without arms, right to form trade unions, associations and cooperative societies, right to reside freely throughout the territory of India, and so on and so forth. But there are also various reasonable restrictions that have been imposed by the Constitution. There are total at least 8 of such restrictions, but not all of them were a part of the original Constitution. Some were added later by means of amendments. Now the question is asking you, which of the above restrictions were part of the original Constitution? So let's first take a look at which of these were original. So the various reasonable restrictions in the original constitutions were, were first, decency or morality, security of the state, then there was contempt of court, and there was also defamation. So these are the 4 original restrictions in the Constitution. But with the help of various amendments, more 4 restrictions were incorporated. So by the first Constitutional Amendment Act of 1951, these 3 were added. Which all? Public order, incitement to an offence, and friendly relations with foreign states. Then again, by another Constitutional Amendment Act of 1963, this was the 16th Constitutional Amendment Act of 1963, another one was added, which was sovereignty and integrity of India. So these are the restrictions that have been imposed on the right to freedom of speech and expression, and these 4 are the ones that were added later on by the means of Constitution Amendment Act. So let's take a look at this. The options here are sovereignty and integrity of India. This was indeed the last one to be added. It was added in 1963. Decency or morality, of course, was a part of the original Constitution. Friendly relations with foreign states was added later by the First Amendment, and incitement to an offence was also added by the First Amendment. So we have only one of the options that were a part of the original Constitution, and hence option A is accurate. Now we have this explanation in detail. You might want to take a look at it. Question 8 says, consider the following statements with regard to Article 14 of the Indian Constitution. 1. Article 14 permits reasonable classification of persons, objects, and transactions by the law. What is Article 14, students? Article 14 is basically dealing with the right to equality, and it talks about equality before law and equal protection of laws. Equality before law and equal protection of laws. Now, when we are talking about equality, we assume that there is absolutely no distinction that is permitted. However, Article 14 does not prohibit any distinction, or it does not prohibit classification. Classification is permitted by Article 14. What is prohibited is class legislation or arbitrary discrimination against a particular class. All right. So this is permitted, this is prohibited. So for example, if I say that I want to alleviate poverty and I enact a law wherein only left-handed persons are going to get benefits of my poverty in alleviation act, then this is arbitrary, this is very random, and this has no logical explanation to it. So classification under Article 14 is permitted on two grounds. First, that there should be a intelligible differentia. What is intelligible differentia? It simply means that there should be a clear basis of distinction. So, in case the government is enacting policies on reservation, if the government is enacting affirmative action policies, then of course it has a clear basis of distinction. Why? Because the policies that the people that are favored by these policies had been historically marginalized in our country. So this makes sense and it resonates with a clear basis of distinction, or it fulfills the criterion of intelligible differentia. The second is rational nexus with the objective of law. So this means that such a law or any policy should be in resonance with or in alignment with the purpose of the law. So I gave you just now the example of, let's say, a law which deals with eliminating poverty in the country but only favors left-handed persons. Now this has no clear basis of distinction. There is no logic behind it. And here, rational nexus with the law means there has to be a logical explanation of why it aligns with the law. So we see that if we allow such a policy, then there is also no clear logical explanation. There is no reason why I support left-handed people or I want them to be out of poverty, but not the right-handed persons or not ambidextrous people, right? So there is no logical explanation, and both these are not fulfilled in a law like that. Whereas here, when I'm talking about affirmative action policies, where I'm talking about providing adequate opportunities, substantial opportunities to historically marginalized people, then of course there is a clear basis of distinction as well as a logical explanation aligning with the purpose of the law. So here, these two are met. Going back, Article 14 permits reasonable classification. Yes, it does. It indeed does. What it does not permit is class legislation. The second statement says the president and governor are fully answerable to courts for actions taken in the exercise of their official powers. So again, the president and governor are exceptions to that law. All right. So if we take a look at Article 361 here, it says that neither the president nor the governor are answerable to any courts for actions taken in the exercise of their official powers, which means no proceedings, no criminal proceedings can be initiated against either the president or the governor during their term of their office. No pending proceedings can be continued, and no arrest or imprisonment can be issued against the president or the governor in their official tenure. Now, of course, civil proceedings can take place, and that can only happen subject to certain conditions, like by giving 2 months notice. So this is inaccurate, and we have option A, one only. Oh, so we are talking over here about not correct. How many are not correct? So again, only 2 is not correct, and therefore we have option B as your correct answer. The explanation in detail, please take a look at it. The next question says, consequential seniority in promotions as mentioned in the Article 16 Clause 4A of the Indian Constitution implies that. What is consequential seniority? So let's understand what this concept of consequential seniority is. See students, this consequential seniority was introduced by the 77th Amendment Act of 1995. And what does it mean? It means that if a person belonging to the reserved category is promoted via reservation, then he or she also retains that seniority over a general category candidate or an unreserved candidate if that unreserved candidate was promoted later. All right. So what does it mean in simple terms? Let's say there are two candidates, candidate A, candidate B. Candidate A is unreserved, candidate B is, let's say, reserved category, right? Candidate A joined service in 2000. Candidate B joined service in 2001. Now at the entry level, who is senior? Naturally, candidate A is senior. However, let's say promotions took place. Now candidate B was promoted in 2010 and this promotion took place by means of reservation. Okay, so promotion by reservation, and this candidate of the unreserved category was promoted in 2012. Who is considered to be senior now? This candidate B, who was promoted earlier, is going to be considered senior and is going to retain his or her seniority over candidate A, who was earlier senior to him at the entry level. This is the whole idea of consequential seniority. Earlier, there was a rule called catch-up rule. And according to this rule, the unreserved category candidate would regain their seniority even if the reserved category candidate was promoted earlier. So that was the catch-up rule. Now that has been done away with. And here we can see reserved category candidates retain seniority gained through reservation in promotion. So option B is our correct answer. Now there is of course the detailed explanation, and here it mentions that this effectively nullifies the earlier catch-up rule which allowed general category employees to regain seniority after being promoted. So then they would be back to the start. Even if the reserved category candidate was promoted earlier and the general category candidate was promoted later, the general candidate would still be considered senior. Now that rule was the catch-up rule, and this has been done away with effectively by the consequential seniority rule. The final question, consider the following statements regarding Article 23 of the Constitution. Statement 1, the right to receive timely and fair wages is a vital part of Article 23. Now, Article 23 of the Indian Constitution does deal with prohibition on human trafficking, begar, and other forms of forced labor. Now, this is the essential meaning that is defined in Article 23. But the judiciary has expanded the scope of Article 23 and has also included any kind of work, any kind of labor that is done in which fair wages are not paid, or there is a delay in the payment of wages, or there is withholding of wages. Because when all these three things are done, then there is a sort of coercion involved, and coercion is leading to forced labor. So our judiciary expanded the scope of Article 23 and said not only the explicitly obvious forms of forced labor are punishable under Article 23, but also any labor where fair minimum wages are denied, or where the wages are delayed, or where they are withheld or not given at all to the concerned person. That would also be problematic and be considered as forced labor. So here, this is statement 1 and it is accurate. The second statement says it allows the state to impose compulsory service for public purposes. Indeed. And why is this mentioned? Because in case of crisis or in case of emergency, the state may actually impose compulsory service on people. So, for example, let's say in dire needs, the state may impose compulsory military service. Now, that will not be called coercion, that will not be considered forced labor, and the government or the state is well within its right to do so. Hence, the statement is also correct, and we have both 1 and 2 or option C as the correct answer. Now, I have brought to you a practice question, but before that, kindly take a look at the explanation. And this is the case that I mentioned. So here I have brought to you a practice question, which is regarding the directive principles of state policy. Please take a look at it and do send me the answers in the comments section. If you found today's video beneficial, if you found it useful and fruitful to your UPSC Prelims journey, please like, share and subscribe. Thanks for watching.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.